A pleasant day to you, ma'am. I am Jovel P. Sagusay, and I'm from BSHM 3B, and this is my Chapter 5 entitled Law on Sales, Agency, and Credit Transactions. Agents should ideally work for the best interest of the client. Because of the trust given them, agents initiate actions, administer, and collect on behalf of the client, according to Elizabeth Wenthrop. Before we proceed to the report, here's are the list of learning objectives. The student are able to describe and explain the nature of sales transactions. The students to be able to identify the functions and operation of agency and industry. And student you're able to identify ways of handling credit transactions. Next is the topic outlines. So first is the requisite of the contract of sale, effect on loss and the object in the contract of sale, double sale, partial restro sale or conventional redemption, obligation of the vendor, the concept of an independent contractor, liability of the principal and the agent, law on credit transaction, and lastly, pactum commercium. Law. In Article 1458, by the contract of sale, one of the contracting parties obligate himself to transfer ownership of and to deliver a determined thing, and other to pay there for a price certain in money of its equivalent. Law on sales. Law and sales in the tourism, travel, and hospitality industry. Agreements arising from a contract will have to be made, and potential breaches from these agreements will be encountered. A contract of sale is one of the usual contracts being encountered by the industry concerned. This will give you an overview of the different sales transactions which may be encountered, including the remedies of the parties concerned. A contract of sale may be absolute or conditional. Requisite of contract of sales. First, consent. Consent is manifested as the meeting of an offer which must be certain and acceptance which must be absolute upon the thing and the costs which are to constitute the contract. Contract entered in a violation of the above shall render the contracts void by reason of public policy and because such contracts are also expressly prohibited by law. Second, object or subject matter. The requisites are as follow. First, it must be existing or possible. Second, it must be illicit. And third, it must be determined in a contract of sale. The thing and the price are the subject matter. The price must be understood to be in money or its equivalent. Next, third, cost or consideration. It represents the way of the contract, the essential reason which moves the contracting parties to enter into a contract. For the seller, the consideration is the price certain in money or its equivalent. For the buyer, the consideration is the thing in the contract of sale. Next, effect on loss of an object in a contract of sale. So here's the law. According to the Article 1480, any injury to or benefits from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of delivery shall be governed by article. So, if the thing is lost before the perfection of the contract is considered inexistent. Therefore, the loss is borne by the seller based on the principle of res spirit domino. It is the owner of the thing who bear the consequences of the loss. And according to Article 1262, an obligation which consists in the delivery of a determined thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he hits incurred in delay. So, if the thing is lost and at the time of the perfection of the contract shall be considered without any effect. So the legal effect is the same of the object is lost before perfection of the contract of sale. And according to Article 1496, the ownership of the thing sold is acquired by the vendor from the moment it is delivered to him and any manner of the way specified in Article 1497 to 1501 or in any other manner or any other matter the signifying an agreement that had a position and transferred from the render to the vendor. So, if the thing is lost after delivery, the buyer bears the risk of loss since delivery transfer ownership, following the principle of the spirit domino. So next, the double sale. The double sale execution should be practiced by a real estate developer engaging in the hotel industry, especially on real property located in potential yet unexplored provinces. So, the principles on double sales will be useful in case an issue on a sale of a real property to different vendors shall be brought before the court of law. So, here's are the law. So according to the Article 1544, if the same thing should have been sold to different vendors, the ownership shall be transferred to a person who maybe have first taken possession in good faith. It should be immovable property. So should it be immovable property, the ownership shall belong to the person acquiring it who is good faith first recorded in the register of property. And also, should there be no inscription, the ownership shall pertain to the person who is good faith was first in the possession, and the absence thereof to the person who present the oldest title and provided there in a good faith. So here is the discussion of law. So the above provision pertain to the same property which has been sold to different buyer or vendors. In case an immobile property covered under the torrent title is sold to different vendors, the one who is the first registrant in good faith at the registry or register of deeds where the property is located shall be preferred. Next is the passio di retro sales or the conventional redemption. So here's the law. According to the Article 1601, conventional redemptions shall take place when the vendor reserve the right to repurchase the thing sold, with the obligation to comply with the provision of the Article 1616 and other stipulation which may have been agreed upon. So here's our discussion of law. So as between an absolute sales and sales with the right to repurchase, no difference exists except that it is latter. The ownership of the purchaser is subject to a resolutory condition that the vendor exercise his right to repurchase within the time of agreed upon. The vendor retro has no right over the thing pending the redemption. He may be, however, register the property in his name, with the express statement of the purchaser right thereto. So, the obligation of the vendor. So, the law. Here are the law of obligation of the vendor in Article 1495. So, the vendor is bound to transfer the ownership of the delivery as well as the warrant thing which is an object of the sale. And according to the Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him. And according to the Article 1497, the thing sold shall be understood and delivered when it is placed in the control and possession of the vendee. So here's our the discussion of law. So under the above provision, the obligation of the vendor are: first, to deliver the thing; second is to transfer ownership of the thing; And third is to warrant against eviction and against hiding defect. Delivery is not only a necessary condition for the enjoyment of the team, but is a mode of acquiring domination and determines the transmission of ownership, the birth of the real right. The fact that the price of the property delivered has not yet been paid in full is not an obstacle to the acquisition rather of the ownership thereof by the vendee, if such a condition has not been stipulated in the contract as in the contract to sale. Next, the concept of an independent contractor. It has been a practice that the hotel and hospitality industry would enter into a contract with cooperative and association engaged in the business of providing managerial or janitorial service and or security services to augment expenses for the payment of wages to employees. So the principle of independent contracting with their cooperative and association is a worthy of study, since an independent contractor shall be primarily and directly able for the wages and other labor benefits and its own employees. So the first one is the contractor has a substantial capital or investment which relative to the job, work or services to be performed and the employees recruited, supplied or placed by such contractor are performing activities which are not directly related to the main business of the principal, or the contractor exercises the right to control over the performance of the work or the contractual employees. Next, the substantial capital or investment. Substantial capital or investment is refers to a capital stock and subscribed capitalization in the can directly used in equipment, implements, machineries, and work premises, actually and directly used by the contractor in the performance of the completion of the job, work of services contracted out. Next, liability of the principal and the agent. So here's the law. According to the Article 1883, if an agent act it in his own name, the principal has no right of action against the person with whom the agent has contracted, neither have such person against the principal. In such case, the agent is the one directly bound in favor of the person with whom he has contracted, as in the transaction where his own except when the contract involved things belonging to the principal. So here's our discussion of law. So when an agent transact business in his own name, it shall not necessary for him to state the name of the principal and shall be directly liable, as if a business were for his over account to the person when whom he transact the same. Moreover, an agent is a personally liable for act beyond the scope of his authority and for acts and violation of the term of written authority. So next is the law on credit transaction. Companies in the tourism industry are unlikely to face debt. That is why it is important to know the different way in handling debt in relation to third person, as well as the credit transaction emanating within their respective companies. So here's the law. In Article 1933, by the contract of loan, one of the parties delivered to another either something not consumable, so that the latter may use the same for a certain time and return it, in which case the contract is called as commoditum, or money or other consumable thing, upon the condition that the same amount of the same kind and quality shall be paid, in which case that contract is simply called loan or mutuum. Commoditum is essentially gratuitous. Simple loan may be gratuitous or with the stipulation to pay interest. Next, the nature of bank deposits. It is clear for the Article 1980 of the Civil Code of the Philippines that the fixed savings and current deposits or money in bank and similar institutions shall be governed by the provision of the Civil Code concerning simple loan mutuum. Hence, a debtor-creditor relationship exists between a bank and the depositor. That is why compensation may take place where its bank may be validly debit the account of its depositor who are debited to the bank by way of loan. Next is the pactum or commercium. So here's is the law. In Article 2088, the creditor cannot appropriate the thing given by way of pledge or mortgage or dispose of them. Any stipulation to the contrary is null and void. So here's our discussion of law. So the pactum commissorium is defined as a stipulation giving power to the creditor to automatically appreciate the thing given and security if the principal obligation is not fulfilled without any formality such as foreclosure, closure, proceeding, and public sale. So according to Jeffrey Gitomer, a great salesperson are relationship builders who provide values and help their customer win. And that's all about my chapter 5. Thank you and have a nice day ahead.